morally repugnant yet constitutionally protected. On October 4th, 2023, a seven-judge bench headed by Chief Justice of India Dhananjay Y.V. Chandrachud and comprising Justices A.S. Bopanna, M.M. Sundaresh, P.S. Narasimha, J.B. Pardiwala, Sanjay Kumar and Manoj Mishra began hearing on a relook at the 1998 Constitution Bench decision in P.V. Narasimha Rao versus State in upholding the immunity of lawmakers from criminal prosecution for alleged vote for money scam in a no-confidence motion in Parliament. The core issue flagged off was that, above all, it must be noted that the purpose of Articles 105(2) and 194(2) of the Constitution is to ensure that members of the Parliament and that of the state legislatures are able to discharge their duties in an atmosphere of freedom without fear of the consequences which may follow for the manner in which they speak or exercise their right to vote on the floor of the House. The object clearly is not to set apart the members of the legislature as persons who wield higher privileges in terms of immunity from the application of the general criminal law of the land, which citizens of the land do not possess. The said case, Sita Soren versus Union of India, arose from allegations that Mrs. Soren, a former member of the Jharkhand Legislative Assembly, accepted a bribe in exchange for voting in favor of a particular candidate in the 2012 Rajya Sabha elections. On September 20th, 2023, the Supreme Court of India overruled the Modi government objection to a referral to a larger bench of 7 and identified the following question to go under the scanner: whether a member of parliament or state legislature enjoys immunity from prosecution for the offence of bribery in relation to his vote or speech in parliament or state legislature. Mrs. Soren argued that she was immune from prosecution under Article 105(2) of the Constitution, which grants immunity to members of Parliament and state legislatures from prosecution for anything said or done in Parliament or a state legislature. However, the Supreme Court expressed doubts about the scope of this immunity the representatives have been enjoying till now, particularly even in cases of bribery under the Prevention of Corruption Act. To an ordinary mortal, it may boggle the mind that a lawmaker enjoyed such an exalted privilege as if an emperor and immunity from criminal prosecution which a commoner did not. After all, the elected representative was a servant of the people. He or she was sent to the legislature to be vox populi, voice of the people. Surely, indulging in bribery as a crime and to speak or vote for lucre cannot be part of a lawmaker's duty. To we the people, it may seem anachronistic that 1998 P.V. Narasimha Rao judgment went the way it did and has survived as good and binding law for 25 years now. We may feel the reference was long overdue. Legally, from an Aam Aadmi perspective, the intent and content of the Constitution are sacrosanct and supreme, not our feelings, emotions, or perceptions. The privilege and immunity is meant for the mythical lawmaker with impeccable credentials of probity, honesty, and integrity. Merely because the mettle of the concerned lawmaker proved to be that of a lesser or tainted being, the constitutional principles cannot be forsaken or whittled down. That is where the mysterious ways of law and constitutionalism may kick in. The Constituent Assembly of India, which sat between 1946 to 1949, debated Article 105 subclause 2 of the Constitution, which grants immunity to members of Parliament from criminal prosecutions when they speak or vote in Parliament or legislatures. Some members of the Assembly argued that the immunity was necessary to protect the freedom of speech and expression of members of Parliament and to ensure that they could freely debate and discuss important issues without fear of legal repercussions. They argued that if members of Parliament were constantly worried about being sued for defamation or other offences, they would not be able to speak their minds freely. Other members of the Assembly argued that the immunity was too broad and that it allowed members of Parliament to get away with crimes. They argued that there should be some limits on the immunity, such as to prevent members of parliament from using their immunity to commit serious offences. The Assembly unit ultimately decided to adopt Articles 105.2 and 194.2, which are in pari materia. However, the Assembly also adopted a number of safeguards to prevent members of parliament from abusing their immunity. For example, the Constituent Assembly made it clear that the immunity did not apply to cases where a member of parliament had committed a serious crime such as treason or murder. The Constituent Assembly debate on the said article reflected the difficult balance that the framers of the Constitution had to strike between protecting the freedom of speech and expression of members of parliament and ensuring that they were held accountable for their actions. We follow the Westminster model, a British legacy. The constitutional law in England, even with no written constitution, for privileges and immunity of parliamentarians from criminal prosecutions for speech made or votes rendered in Parliament, is based on Article 9 of the Bill of Rights of 1689 vintage. It means that members of Parliament are immune from criminal prosecution for anything they said or did in Parliament, for both speech and votes. In fine, in constitutional democracies, it would appear that if a lawmaker took a bribe outside the legislature and delivered on his promise by speaking or voting as committed, the Constitution commends the immunity from criminal prosecution as a parliamentary privilege. It is not condoning the crime. It is in recognition of free speech and independence of our lawmaker. If our lawmaker chooses to sell his speech or vote, our remedy may only be to throw him or her out in the hustings. For the Constitution says so, and it alone is supreme, as we have always believed it to be true. If one reads the tea leaves right from the 2-day proceedings before the 7 judges bench, moral repugnancy may yet prevail, insofar as bribery or criminality took place outside the legislature and a vote inside the house was just the performance as quid pro quo. Thankfully, it appears that Prevention of Corruption Act may well unsheath the immunity and privilege to this extent, as it did with Chief Justice K. Veerasamy of Madras High Court in a different context long ago, or so one believes. We may yet, however, have to wait for what the law lords on the 7 judges bench may yet pronounce.